What the Department of Justice has challenged is the provision in the settlement that requires buyers and their buyer's agents to enter into a written agreement prior to tearing out. So that is a requirement now, by the way. So all you home buyers out there, it is now a mandate at the highest levels.
Yes.
That realtors, members of the National Association of Realtors, have a written agreement with a buyer before we show you a home.
Absolutely.
And so I'm not going to get into what those written agreements look like because it's different everywhere. But essentially, basically in the state of Missouri, the agreement that we have is called a buyer's agency, and it creates a buyer's agency between an agency agreement between the buyer and the agent that they're hiring.
Yes.
So that was what the Department of Justice was challenging. Those agreements have always existed, but we didn't typically use them until an agency relationship needed to be created. And that could be at any step during the transaction if you're doing things right.
Yes.
So now we have to have that at the very, very beginning because it does spell out who's paying what in terms of commission. And we've already hashed over this in previous episodes. So you can go back and watch some of those and kind of figure that out. But that was the Department of Justice. That was their main. They don't like that. And so the judge in this case disagreed and approved the settlement. So it's done. That was November 26th.
True. And now all talks commissions and all the things they wanted enacted have been enacted. And now comes phase 2, which is the question of said written buyer agreements and